Good morning. The committee will come to order. We on the Oversight and Government Reform Committees exist to secure two fundamental principles. First, Americans have a right to know that the money Washington takes from them is well spent. And second, Americans deserve an efficient, effective government that works for them. Our duty on the Oversight and Government Reform Committee is to protect these rights. Our solemn responsibility is to hold government accountable to taxpayers, because taxpayers have a right to know what they get from their government. It is our job to work tirelessly in partnership with citizen watchdogs to deliver the facts to the American people and bring genuine reform to the Federal bureaucracy. Today's hearing represents what we would consider the front line in the whistleblower protection issue. This committee's efforts, both in bipartisan legislation, the first time in more than a decade, to pass new whistleblower protections, and our recognition that we need to hold government accountable to the American people by protecting whistleblowers when they allege or uncover wrongdoing. This committee, on a completely nonpartisan basis, has always sought to protect whistleblowers, whether they come forward in a Republican administration or a Democratic administration, whether it points to the Oval Office or just to the office next door for some harassment. Whistleblowers deserve to be heard and protected. 2 weeks ago, the Department of Energy Inspector General issued a management alert warning about Bonneville Power. We do not seize on every management alert. We consider the 7-day notification and these kinds of alerts as an opportunity to ask, should we look into this? Can we make a difference? Is it appropriate for us to act because what we see could go beyond the four corners of the particular agency, or because there is more beneath the surface? In this case, the most important question for us is, when Bonneville Power apparently and deliberately began disadvantaging veterans and other applicants, they did something that goes at the very heart of the Federal employment and hiring systems. There is more or less 1 million Americans who put on a uniform every year, and 2 million who do not. All of them are Federal employees. But a large number have done both. We have been well served by men and women who serve our country at the risk of life and limb, and then go on to have short, medium, or very long careers of public service in our civilian workforce. Certainly at the Department of Defense, the nexus between what they learned on active duty and what they do helping those who are still on active duty is critical. At the Post Office, one of the largest single employer of veterans, men and women every day trust that their mail will be delivered by people whose integrity is shown by their willingness to put their life on the line. Let me be perfectly clear. The primary concern we have today is the apparent retaliation against whistleblowers. It's illegal, and we won't stand for it. We want to make sure the truth gets to the American people. We clearly believe in this case there are two issues: protect the whistleblowers and send a strong message from this committee that the special and earned status of hiring for our veterans is in fact codified in law and universally believed by people on this side of the dais. Consequently, this hearing will be the beginning of what will be a dual investigation, one working hand in hand with the IG, one in which, as my ranking member and I coined in an earlier investigation, we will look over his shoulder. However, we reserve the right to go independent if necessary. We do so because there are two issues. When it comes to investigating, IGs have certain privileges and authorities, but not as many as we have here. For that reason, at the beginning of this hearing, I want to make it clear, if the IG does not get full cooperation in the investigation, or if for any reason someone falls outside the ability for the IG to get testimony, we will back that authority up. The Department of Energy's recent reversal of the retaliation against personnel is a positive step. I don't want to let that go unnoticed, but make no mistake, we expect people not just to be reinstated, but to be treated in a genuine, appropriate way as people who have done the right thing, not people who have broken some sort of silence within any agency. And with that, I thank our panelists and ask the ranking member for his opening statement.
Thank you very much, Mr. Chairman. Today, we are here discussing a preliminary management alert issued by the Inspector General of the Department of Energy on July 16th, related to the Bonneville Power Administration, also known as BPA. For those not familiar with BPA, it is a unit of the Department of Energy based in Portland, Oregon, that is self-funded and receives no appropriation. It has approximately 3,100 employees with no political appointees, and it supplies electricity from hydro and other types of power plants to western states, including California, Idaho, Nevada, Oregon, Utah, Washington, Wyoming, and parts of Montana.
You can call it God's country for short.
The IG's alert covers two major allegations. First, it finds that BPA engaged in prohibited personnel practices from November 20th, 2010 to June 2012. Specifically, the alert states that BPA's actions resulted, and I quote, in the inappropriate exclusion of veterans and other applicants from consideration for selection. The second major allegation is that, and I quote, BPA initiated questionable adverse personnel actions, end of quote, against employees who raised concerns about hiring problems with the IG and others. The IG alert says this: while we are not in a position at this point to conclude that the actions taken thus far are retaliatory in nature, we are deeply concerned. I'm also very concerned. We're fighting a war that has lasted more than a dozen years. American soldiers are arriving home every day, and they face common worries in my district and districts all over the country. They ask themselves, how will I support myself when I take off these fatigues? How will I support my family when I hang up the boots? For their service and sacrifice, words of thanks from a grateful nation are not nearly enough. We need to continue moving service members from our armed forces to our workforces as seamlessly as possible. In addition, our committee is in particular takes very seriously its role with regard to protecting whistleblowers. I do not want to get ahead of the evidence or the IG's investigation, and I understand that there have not been any findings of retaliation, but we have to treat these allegations carefully, responsibly, and thoroughly. If allegations of discrimination against veterans or retaliation against whistleblowers prove true, those responsible must be held accountable for their actions. Despite these troubling allegations, I'm encouraged with the proactive nature of the IG's investigation and the very swift response of the Department of Energy. The IG made two preliminary recommendations in the alert while they continue the investigation. First, they recommended that all ongoing disciplinary actions against BPA staff be suspended until the IG completes its work and issue its final results. Second, they recommended that any employees facing removal or suspension be temporarily restored to their positions. In response, the Department not only implemented these recommendations, but took a number of additional steps to aggressively address these issues. The Deputy Secretary named a new acting administrator of BPA, instructed the new administrator to immediately direct all employees to fully cooperate with the IG, initiated an immediate review of BPA management, and suspended all adverse personnel actions pending further review. Let me read the IG's very positive assessment of the Department's actions to date. The Department expressed its concurrence with the facts presented, the conclusion reached, and the recommendations provided in its management alert. Notably, the Department initiated immediate corrective actions which were fully responsive to our findings and recommendations." End of quote. Finally, I understand the limitations of today's hearing. The IG's conclusions are preliminary. The IG has made it clear that the investigation is ongoing, and we will look forward to a final report when the investigation concludes. Also, because we do not have final conclusions, we understand that today's witnesses may not be able to discuss some issues due to the Privacy Act and other constraints. With that, I thank the witnesses for their participation in today's hearing, and I look forward to the testimony. With that, I yield back.
Thank you. All members will have 7 days in which to put their opening statements. We now welcome our first panel of witnesses. The Honorable Daniel Poneman is Deputy Secretary of the United States Department of Energy. Welcome. The Honorable Gregory Friedman is the Inspector General of the United States Department of Energy and the primary reason we are here today. Welcome. Anita Decker is the Chief Operating Officer for the Bonneville Power Administration, or was, and we will discuss that further. Pursuant to the committee rules, I would ask all three of you please rise to take a sworn oath and raise your right hands. Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Please be seated. Let the record reflect that all witnesses answered in the affirmative. Pursuant to ensuring that all witnesses are ready and able to give testimony, I've just got a few questions that are going to be required for Anita Decker. We've been informed that DOE believes you're appearing in your personal capacity. Were you told that?
Yes, I was.
Ms. Decker, you are currently employed by the Bonneville Power Administration. Is that correct?
Yes, Mr. Chairman.
Mr. Decker, Ms. Decker, you are currently being paid by Bonneville Power Administration. Is that correct?
This is correct.
When were you first hired by Bonneville Power Administration?
In October of 2007.
Thank you. Have you been an employee of Bonneville Power Administration since then continuously?
Mr. Chairman, there was a period of time when I was on a detail assignment for the Western Area Power Administration from August of 2012 till April of 2013.
And that falls within what many of us think of as Bonneville Power, this group of related organizations. Is that correct?
The Western Area Power Administration is not.
It's not Bonneville, but it's one of the four or so.
Correct.
Okay. And this was an assignment that the Department of Energy chose to have you move from one to the other. It had to be approved. Okay. And I'll ask this because it's required in this. Bonneville Power is part of the Department of Energy. Is that correct?
That's correct.
The Western Area Power Administration is part of the Department of Energy. Is that correct?
That's correct.
And the Department of Energy is part of the executive branch. I'll answer yes for that one. Did the Department of Energy pay for your transportation here today as far as you know?
Mr. Chairman.
Either directly or through Bonneville Power?
Mr. Chairman, yes.
Are you receiving per diem for your travel here today as far as you know?
Mr. Chairman, yes.
When were you placed on administrative leave?
Mr. Chairman, I was placed on administrative leave on July 15th, 2013.
And roughly when do you believe you were restored from that position?
So, Mr. Chairman, I was restored on Sunday afternoon in order to just prepare for testimony and to appear today. Okay.
Did you have access to official emails in preparation for today's hearing?
Yes, I did.
Were you instructed by the Department of Energy that you are here today only in your, I asked this before, personal capacity?
Mr. Chairman, that's correct.
Who gave you that instruction?
The instruction was provided by one of the Department of Energy's general counsel to my counsel.
Okay. Deputy Secretary Bonneville, were you aware of that instruction?
Mr. Chairman, when I read Ms. Decker's testimony last evening was when I saw the comment about the personal capacity. That was the first time I had heard about that. So
you weren't consulted in this process?
No, and there's a difference as I asked the question because I hadn't seen it before. As I understood it when I asked our own staff, Ms. Decker is speaking in her capacity of her personal actions in this matter, but not as an individual citizen. In other words, she's restored to her Bonneville employee status to precisely cooperate with this committee.
Okay. And I'll shortcut as quick as I can through these questions. Do you, Secretary Poneman, understand that there would be any restrictions on her full ability to answer about what she did in her official capacity during her entire tenure with the Department of Energy?
Neither she nor anyone else would have any such restrictions, sir.
Do you agree that when someone is asked questions about what they saw, heard, and observed or did during the time in which they are a Federal employee, that is not a personal statement, but rather an answer as to their professional activities?
If the question is about professional activities, by definition, that is what they are talking about.
Okay. And the reason I've gone through this is it is the Chairman's decision that Ms. Decker, from what I can determine, is here as a Federal employee, in no way in a personal capacity. To the best of my knowledge, no one on the dais has any questions as to your activities outside of your official capacity as a government employee. And so although General Counsel often makes statements, I want to make it clear, and if there's any question or dissent, I want to hear it, that as Federal employees, you are here to represent the positions you have and the observations you have, and in no way is that personal. Now, Secretary, you will speak on behalf of the Department of Energy from a standpoint of your personal or your opening statement and cleared activity. Is that your understanding?
Yes, sir.
Okay. So I'll recognize the ranking member if he has any questions.
Yeah, I have a number of questions.
I wanted to make sure this was clear because we often do bring people in personal capacity. Whistleblowers, for example, are not here in their personal capacity. They're here on behalf of their activities related to the official activity. And I wanted to make sure there was no misunderstanding that Ms. Decker is here as a Federal employee, here to discuss her activities as one of the many people we're very proud of as Federal employees with a long career, and not in some sort of non-government way. And perhaps lawyers have a technical understanding that I don't, but our counsels could find no basis for the word personal to be used. Understanding, Ms. Decker, you do not speak on behalf of the Department of Energy, but you do speak on behalf of an organization you ran, and that is in both of your capacities. Ms. Friedman, do you have any questions on this line of clarification?
I do not, Mr. Chairman.
Thank you. Mr. Cummings.
Ms. Decker, first of all, thank you for being here. I think we can be even clearer, no matter what the terms are. You said that you were restored to you were put on administrative leave, I think you said, on July 15th.
That is correct.
And then you said that you were restored last Sunday. Is that right?
That's correct.
About what time was that? Somebody called you?
Yes. I want to say that it was about 11:30 or so on Sunday morning, Sunday afternoon.
And so you were, but then you said something that you said that you were restored so that you could come back, could do this hearing. Is that right? Is that something? What did you say?
So, Representative, excuse me. What I understand is I was taken off of administrative leave for the sole purpose of preparing testimony for this hearing, and that when I return to Portland, I will be placed back on administrative leave.
All right. And so now with regard to your testimony, you talked about, mentioned in your personal capacity. Did you mention that? And I think the Chairman talked about it. Personal capacity, were you told that that's what your testimony, the range of your testimony would be? You would be testifying in your personal capacity?
Yes, that's correct. What I was told was I would be testifying in my personal capacity of my personal knowledge, and that I would not be speaking on behalf of Bonneville, and that DOE would be the spokesperson for the Bonneville.
And so, but with regard to, based upon what you just said, do you feel limited in what you can say today? Do you believe that you were being limited in what you could say?
I don't believe I'm being limited in what I can say, but I would reiterate the instructions I've been told is that I'm not speaking for DOE in regard to Bonneville.
And so going back to what the Chairman said, so we won't get caught up in legalese, you feel, and just correct me if I'm wrong, you feel that you're free today to speak under oath about what you have observed, what you have experienced, what you have seen in your capacity as an employee of Bonneville. Is that a fair statement?
Representative, what I would say is that my personal knowledge does include what I've experienced, what I've felt, and what I have done. I've been at Bonneville, so I would say yes.
Very well. And Mr. Poneman, you said that you had no knowledge of this personal capacity situation. You did not?
When I saw Ms. Decker's testimony last night, that was the first time I either saw or heard the phrase, sir.
And so you just heard what she said, did you not? Did you hear what she said?
Yes, sir.
And does that sound reasonable?
To me, sir, it's pretty simple, and without getting caught up in the legalese, precisely because our policy is and will always be any Bonneville or any DOE employee has full freedom to cooperate with any proper investigation such as this one. It is to that purpose that Ms. Decker was restored. She was not restored in the other capacities of Chief Operating Officer and so on. So I think the confusion might be the word personal refers to her personal knowledge of what happened, anything that's of interest to this committee, but in terms of the broader operations of Bonneville today, oversupply, Columbia River Treaty, all of that stuff is not within the scope of the restoration.
The good news is we're not going to ask what it is with certain units offline or the capacity of transmission lines. So
I know you know about these things, Mr. Chairman.
But I do serve on the other committee, and someday we may come back and ask.
I recall, sir.
This is my last question. I note that there's a management alert, and this management alert on page 5, it's an attachment. It says, and I'm pointing this to you, Mr. Poneman, it says the Deputy Secretary also directed the Administrator to immediately convey to all BPA employees that they can cooperate freely with the OIG and other investigations without fear of retaliation. You're familiar with that?
Yes, sir.
Is that accurate?
Yes, sir.
Very well.
Thank you,
All right,
gentlemen.
thank you.
We now recognize our first witness, Mr. Friedman.
Chairman Issa, Ranking Member Cummings, and members of the committee, I appreciate the opportunity to testify at your request in the Office of Inspector General's July 2013 Management Alert concerning alleged whistleblower retaliation and prohibited personnel practices at the Bonneville Power Administration. Bonneville and its nearly 3,100 Federal employees are responsible for marketing electric power to all or parts of 7 or 8 states in the Pacific Northwest. My office is currently reviewing allegations that Bonneville engaged in inappropriate hiring practices that violated the rights of applicants for Federal positions, most notably applicants entitled to veterans preference. During this review, we learned that Bonneville employees who had raised questions regarding violations of personnel practices may have been subjected to retaliation, and that several of these individuals had already filed retaliation complaints with the U.S. Office of Special Counsel. As troubling as we found these allegations to be, our concern intensified when in July of this year, Bonneville employees indicated that additional retaliatory actions were imminent. We deemed the sources of the allegations to be credible. Thus, we brought this matter to the attention of the Department's senior leaders in the July 16, 2013 Management Alert. We use management alerts in time-sensitive situations that require immediate management consideration. We concluded that expedited action to protect the involved Bonneville employees was of paramount importance. The management alert included recommendations to ensure that all Bonneville employees feel that they can report potential wrongdoing in an atmosphere free from retaliation. Commenting on the alert, the Department concurred with the facts, conclusions, and recommendations, and the Department outlined a list of corrective actions that had been taken or were to be taken, and informed us that the Deputy Secretary directed the Administrator to convey to all Bonneville employees that they can cooperate freely with the OIG and other investigations without fear of retaliation. I would like to address the status of our ongoing work regarding the core allegation that Bonneville had engaged in inappropriate hiring practices. As background, on May 11, 2010, the President issued a memorandum requiring the use of category rating for personnel recruitment and hiring. One objective was to increase the candidate selection pool while still complying with merit system principles, including veterans' preference. Thus, as of November 1, 2010, Bonneville was required to use category rating to rank candidates for competitive positions. One critical component of this process is that the quality category definitions, the basis for formulating the best qualified list at Bonneville, must be developed before the vacancy announcement goes public and cannot be changed once the vacancy is opened. This is to assure fairness, equity, and consistency. As noted, it was alleged that Bonneville's practices had effectively disadvantaged job applicants, most notably those entitled to veterans' preference. We found the Department had received the same allegations and initiated a review of relevant hiring actions in Bonneville's policies and practices. This resulted in the February 2013 memorandum to my office, in which the Department itself identified prohibited personnel practices at Bonneville, which it described as systemic. We promptly initiated a review to determine the underlying causes of these problems. Our preliminary findings validated the concern that Bonneville had adjusted quality category definitions after vacancy announcements were closed and applications were received. These matters have also been the subject of internal reviews by Bonneville itself and by the U.S. Office of Personnel Management. These examinations have been extremely revealing. Our summarization of the data developed by Bonneville shows that it had engaged in inappropriate personnel practices in 65% of its competitive recruitments, that is 95 of 146 cases, conducted from November 2010 to June 2012, confirming in essence the allegation that the best qualified list had been modified after applications were received. Clearly, as a consequence, veterans and other applicants were inappropriately excluded from consideration for job selection. As has been noted, our review is still in process, and therefore the statistical analysis that I just gave you may change as new information becomes available and as we analyze the new information. We were told that Bonneville changed its work processes and issued new guidance in May 2012 to stop these practices. However, most importantly, Bonneville failed to take required action to notify the negatively impacted applicants and address the impact associated with the prohibited practices. As of June 2013, Bonneville's hiring authorities have been suspended. These actions were taken because both OPM and the Department concluded that there were major errors in Bonneville's personnel files. Our emphasis was and remains establishing the cause of the improper practices. And I would like to stress again that our management alert was preliminary. Our work with regard to the substance of these allegations is not complete, and it continues. Additional interviews and document searches are underway. We intend to complete the effort as promptly as possible. This concludes, Mr. Chairman and members of the committee, this concludes my statement. I will be happy to answer any questions that you may have.
Thank you. Secretary Poneman.
Thank you, Chairman Issa, Ranking Member Cummings, and distinguished members of the committee. Before beginning my prepared remarks, I would like to pause to acknowledge the untimely passing of Mr. Benjamin Kuhl, a Wilson Construction employee who died earlier this week while working at a Bonneville power substation in Oregon. Our thoughts and prayers go out to him and to his family. This tragedy starkly reminds us of the dangers as well as the awesome responsibilities of those who work on our electric grid. It also reminds us of how important it is to make that extra effort to do our job safely and always to look for ways to improve our performance. And indeed, our management principles tell us that we must do our work safely and continuously improve in our efforts. I have been invited here today to discuss the Bonneville Power Administration and the allegations of questionable personnel practices at BPA. The Department of Energy takes these allegations very seriously. We share the committee's deep concern regarding the Inspector General's preliminary findings. We have responded forcefully to those findings and continue to provide aid and assistance to aid in the completion of the IG's investigation of BPA. We also continue to provide guidance and support to BPA management as they carry on the work of BPA in all of its dimensions, including human capital management, but extending to the full suite of BPA missions in all of their diversity. In the matter being reviewed by this committee, as the IG recognized, the Department initiated immediate corrective actions which were fully responsive to its findings and recommendations so far. As the IG continues its investigation, we look forward to a full accounting of the facts so we can carefully consider and implement any actions that may be appropriate. The history of BPA dates to 1937, when President Franklin Roosevelt signed the Bonneville Project Act to deliver the massive benefits of Columbia River hydropower, clean, inexpensive electricity to citizens of the Pacific Northwest. 4 years later, BPA hired Woody Guthrie to write 26 songs in 30 days about the Columbia River hydro system for the princely sum of $266.66. This is an organization, in short, Mr. Chairman, with a great history and a great tradition, and it has played a major role in the development of the Pacific Northwest. For all its storied past, Bonneville remains vitally important today in serving the energy needs of the citizens of the Pacific Northwest. Specifically, it markets wholesale electric power from 31 federal hydropower projects in the Columbia River Basin. While part of DOE, BPA, as Mr. Cummings has noted, is self-funding and covers its costs by selling its products and services to ratepayers and through borrowing from the U.S. Treasury. In 2012, DOE received a complaint alleging prohibited personnel practices at BPA and provided this information to the Inspector General. The Inspector General informed the Department that it had also received a similar complaint. The IG subsequently requested that DOE review these matters. DOE conducted a review of the hiring cases identified in the initial complaint and briefed the IG on the findings. Included in the Department's findings was concern that BPA had not followed the personnel requirements related to veterans hiring practices. Based on these initial findings, DOE took a series of actions to address the situation at BPA. First, DOE required BPA to submit all cases involving hiring from the general public to DOE for review and concurrence before proceeding. Second, DOE subsequently formally suspended the BPA administrator's authority to conduct hires from the general public. And third, based on the preliminary findings from the June 2013 audit, DOE formally suspended BPA's authority to conduct hiring from within the existing federal workforce. Based on its June 2013 audit, DOE also outlined steps BPA needed to take to correct its hiring procedures. DOE continues to provide support to BPA to assist Bonneville in taking corrective actions as needed and to develop and implement sound human resource processes and procedures. As the committee is aware, the IG and others have also indicated there were allegations of retaliation against BPA employees who were cooperating with the IG's investigation. Let me be clear. DOE is strongly committed to a workplace where all workers are free to speak out, voice concerns, or lodge complaints without fear of retaliation. For this reason, we were seriously concerned when we learned, after the fact, that BPA had issued a notification of proposed removal against a potential whistleblower. DOE then took swift and decisive action. First, DOE requested that BPA provide all documentation associated with proposed adverse actions. Second, DOE temporarily suspended BPA's authority to take any adverse personnel actions and instructed BPA to provide DOE headquarters with all information on any adverse actions in process or under consideration. Third, as has been noted already, I directed the administrator of BPA to take no adverse personnel actions against BPA employees, to immediately suspend any such actions that had already been taken, and to instruct any such employee then on administrative or any other type of leave to return to work immediately. I also directed the BPA administrator to provide a full, prompt report of any actions that conceivably could fall into these categories. Furthermore, I directed the Administrator to immediately convey to all BPA employees that they can cooperate freely with IG and other investigations without fear of retaliation. Finally, I sent a team to BPA to conduct a management review and named Elliot Mainzer as Acting Administrator of BPA on an interim basis. In conclusion, we recognize the Committee's interest in this matter and share your objective of remedying any deficiencies in personnel practices at BPA. We look forward to a full accounting of the facts once the IG's investigation is complete so that we can evaluate the situation and, as necessary, build on the steps already taken to assure that BPA staff understand Federal hiring rules and have the capability and systems in place to implement them appropriately. BPA remains committed to performing its mission and to serving the nation, the region, and its customers while ensuring continuity and stability in its operations. The Department will be working actively to support Bonneville as it continues to fulfill these vital responsibilities and to make progress on critical issues facing the organization and the region. We are all grateful for the dedicated service of the thousands of BPA employees who strive every day to fulfill their mission. Mr. Chairman and members of the committee, this completes my prepared statement. I would be happy to answer your questions at this time.
Thank you. Ms. Decker.
Chairman Issa, Member Cummings, and distinguished members of the Committee on Oversight and Government Reform. I am here as a result of acceptance of the Chairman's invitation, which I initially declined. Given my limited ability to prepare, the lack of final findings or resolution on personnel matters at issue, and my tenuous position of being on administrative leave have given me pause. On July 15th, as you've already established, I was placed on administrative leave by DOE. The memorandum I received recites allegations that BPA engaged in improper hiring practices, violations of veterans' preference and merit system principles, and allegations of whistleblower reprisal. There are no particular allegations against me specifically. I have not been allowed to access the BPA buildings, documents, personnel, or computer systems up until this Sunday. So I have only had limited time to prepare. So I hope you will give me a little bit of grace for that. I would like to state that I would never knowingly allow BPA to implement policies or practices that violate Federal veterans hiring. I am proud of BPA's record of veteran hiring, both personally and professionally. My father served in the U.S. Navy. My stepbrother retired from active duty as a U.S. Marine. My stepsister left the Air Force after 14 years of service and then spent 19 years in the U.S. Air Force Reserves, including being deployed to Iraq. I have a stepson who served in the U.S. Navy who is now working for the Post Office as a contractor. So the importance of the veterans' preference does not escape me. It has personal meaning for me. I have actively supported veterans personnel, and I was extremely proud for Bonneville to be recognized for supporting veterans and for me personally to be recognized by Bonneville's veterans. The main issue regarding BPA hiring practices had to do with BPA's interpretation and implementation in late 2010 of the category rating process envisioned in improving the Federal recruitment and hiring process. BPA's implementation of how to apply the category rating was incorrect. That said, the issue was identified by BPA staff in May of 2012. At that time, more than a year ago, BPA stopped the practice that was in question. In July of 2012, I learned that either there had been or there was going to be a complaint issued to the IG. I responded as described in my written testimony. When I left Bonneville in August of 2012 to serve as acting administrator of the Western Area Power Administration at the request of DOE, I thought the hiring issues would be timely resolved. Most importantly, for me before I left, was the fact that the hiring practice that had disadvantaged both veterans and non-veterans had been stopped. I returned to Bonneville 8 months later, in April of 2013. Upon return, I found that the reconstruction process, the required process when a veteran has not been granted the proper preference, had not yet been completed. A variety of factors combined to delay that resolution, but both BPA and DOE have first attempted to ensure that we have all of the issues that need to be remediated for before we begin remediation. With respect to the allegations of retaliation against whistleblowers, I can assure this committee that I take that very seriously, and I understand the sensitivities associated with protecting whistleblowers. While the actions in question in the IJ management alert are in my line of responsibility, I am not the decision maker of the proposed actions. While I might be aware of some of the actions, my primary interest was, are those actions following the appropriate personnel actions and processes that are designed to protect both the individual and the agency and taxpayers, and in this case, Bonneville's ratepayers. I also take performance management very seriously and believe the Federal personnel system contains checks and balances intended to protect the agency's ability to fairly manage performance and protect employees from retaliation. My personal belief, my training, my legal advice from BPA counsel have made it very clear there is zero tolerance for retaliation. It also counsels that making a complaint or other protected activity does not insulate an individual from performance accountability solely because that person engaged in a protective activity, such as complaints or cooperating in an IG investigation. In summary, in regard to retaliation, until the investigation, audits, and legal determinations are final, jumping to conclusions is inappropriate and may do unintended damage to effective and efficient government and to public servants. In regard to veterans, we made a regrettable mistake. We stopped making that mistake over a year ago. I want to be part of making this right. Mr. Chairman, I'm happy to answer any questions.
Thank you. I recognize myself. Ms. Decker, you're senior executive service.
Correct.
I just want you to be aware that there's a bill on the floor today. If that becomes law, it would require, before you be terminated, that you be told at the time that you would be removed, and with 30 days to remedy it, what you're being accused of. Not everyone on the dais is going to vote for that, but I will be one who will support that. I'm not a fan of long administrative leaves, and I'm completely opposed to people being on the payroll, off the job, and neither accused nor in a position to even prepare to explain what happened as time goes by. I don't think that's good management practice. But I want to ask you a specific question, and perhaps in a sense this will be more of a personal question. Could you briefly tell us when you learned that you were being put on administrative leave and the events that occurred in those first few minutes when that happened?
Mr. Chairman, so I had an email that said I needed to be available for a phone call at 9 o'clock. A woman from Bonneville, or from DOE's Human Capital Office, called me and said that an individual was going to bring me an envelope, and there would be a knock at my door, and there was, and I was handed an envelope, and inside that envelope was a memo from the woman I was talking to on the phone that said, as I said in my oral statement, Bonneville was under investigation and that she had been delegated the authority to put me on administrative leave, and therefore she was. And the letter gave instructions of what I needed to return in terms of government property, and that I would need to check in every day until further notice. And the gentleman who handed me the envelope came and I gave him my government possessions, and he walked me out of the building.
Let me paraphrase that. They sort of took your gun and badge and walked you out virtually at gunpoint. You were not allowed to do anything except walk out of the building, and it was a fairly public display, wasn't it?
Yes.
Have you seen that done before at Bonneville? Is that a standard practice?
I would not call it a standard practice. There are times when someone has been notified that they are like in a proposal, or if they're going to be on administrative leave for cause, that is the process that Bonneville follows as well.
But you were not told you were on administrative leave for cause?
No.
Okay. Secretary, you you talked in terms of a fairly aggressive action once you became aware of this. But let's go through, based on what Ms. Decker said. One, DOE knew about this more than a year ago, correct?
Mr. Chairman, when you say this, what are you referring to?
Well, you knew about the wrong use of the hiring practices, the discriminatory hiring practices, in May of last year.
Mr. Chairman, there was an anonymous complaint that was filed in May of last year. That's correct.
Well, Mr. Friedman, maybe I'll go through it with you quickly. Between May of last year and the time Ms. Decker was walked out of the building, was there a time in which whatever, and we don't want to get into details of why she's on administrative leave, but was there a time that people knew that there was a there that was well before that day? And more importantly, as I understand it, Ms. Decker was gone for 8 months. Basically, during the 90 days or less in which she returned, was there some action that triggered her being placed on administrative leave? And you don't have to tell me what it was, but administrative leave and the need to remove her from the building in that way.
Well, let me take two parts, treat that in two parts, Mr. Chairman. First of all, there were a number of people within the Department of Energy who were aware of the fact from June 2012 to the date that these events took place that you're referring to, that there was a problem or there was an alleged problem with regard to personnel practices at Bonneville. So to set the stage, I think you're right about that. With regard to any individual being placed on administrative leave, I did not recommend that. I did not suggest it. I wasn't consulted and given a thumbs up or a thumbs down, so I can't fill in the details as to what transpired and the thought process behind that. Okay, but at this point you've reached a conclusion, which was they certainly broke the rules when it came to hiring, and it worked to the detriment of veterans. I reached the conclusion, the Department's Human Capital Office reached the conclusion, and the Office of Personnel Management have reached that conclusion. Okay, two more quick questions. One, we have the name of 5, but there are, if I understand, at least 6 people who qualify, in your opinion, as whistleblowers in this case, who went to the Office of Special Counsel, et cetera. Yes, that's roughly correct. Okay. If the number is not right in another setting, we'd appreciate it. We'd also appreciate the names. Mr. Poneman, I'm going to be very brief. One, you mentioned privacy in your opening statement. You do understand that we're not covered by privacy laws. Congress specifically exempted itself from that, so we're entitled to things which would otherwise not be available under the Privacy Act.
Mr. Chairman, I'm referring to restrictions I'm told I'm subject to under the Privacy Act, sir. Okay. Because we have a number of things we want to make you aware of. First of all, we've sent you 2 letters. One received no response whatsoever, and that was July 16th. And the second one, we're not happy with the response. We'll talk to you offline. Before I yield to the ranking member, the point that I want to make is this. We expect if something cannot be said in an open hearing, if it's sensitive, prior to that hearing, we get a full and complete either in-camera or otherwise arranged review. We're not as well prepared as we'd like to be today, particularly because immediately after the notification, we sent a letter and got no response, and the letter was addressed to you. Congressman, we always seek to be cooperative with this committee. It was my understanding that the letter that had been sent was responsive to both of your incomings, which came in the space of about a couple of days. But
well, Mr. Secretary, just so you know, and I'm going to yield to the ranking member, you didn't even call us and know there was no written response. So you represent the administration. Understand this is an administration who has systematically not responded. So we've known each other a long time, but you get a little tarred and feathered if you act like many other administration officials, and we get that kind of non-response. This is not something, as I told you when we talked privately, this is something where we think it's fairly local, fairly contained, but it really encompasses an important message both on whistleblowers and veterans that I think the committee wants to make sure that we shed light on and spread the word throughout the administration. So I'm not going to belabor this. I expect that we get full cooperation. You and I have a past where I think we have great respect for being able to work these things out. Mr. Cummings?
Speaking of what the Chairman left off, I have a letter here dated July 24, 2013, that I received a copy of that was addressed to the Chairman from Eric Fiji. Is that the
Fiji, sir.
And now, were you aware of this letter? And
Yes, sir.
it seems to be not your response, but he refers to the letter of July 16th and July 17th in this letter. Were you aware of this?
Yes, sir.
But you did not personally provide a response to the Chairman. Is that right?
My understanding that this letter, I think, is fairly standard procedure, was the response from the Department on my behalf. And I'm here today, sir, as I always do appear, because we do completely accept the oversight authorities that you all have, and we are committed to being cooperative.
Mr. Freeman, let me ask you this. You were, in response to one of the Chairman's questions just a moment ago, you said that you had nothing to do, you rendered no opinion with regard to Ms. Decker being placed on administrative leave. Is that what you said?
Yes. I think, in fairness, Mr. Cummings, that I was told a day or two in advance that that was the plan, but it was not my recommendation.
Is that something you would opine on? I mean, is that something that you would normally provide an opinion on? I'm just curious.
Under these circumstances, probably not.
I see. So I just wanted to clear, you sounded as if you were disappointed that you didn't have something to say about that. And I just wanted to clear it up because
I appreciate the question. The answer is if I expressed, if I conveyed a disappointment, that was not accurate.
All right. Mr. Freeman, your management alert says this, and I quote, Bonneville engaged in prohibited personnel practices in 65% of its competitive recruitments conducted from November 20th to June 2012. I got to tell you, as I listened to all of this, having been in my early practice back in the late 1970s, to be in civil rights practice and to have seen so many people discriminated against, I take this whole episode very seriously because I know the damage that it does, and as far as I'm concerned, it's criminal when people deprive people of their rightful opportunities. But can you explain to me very briefly how veterans applying for these positions were disadvantaged by these actions?
Yes, it's nuanced and subtle, but let me try to make it as simple as I possibly can.
Okay.
Under the system that was in place after the President's memorandum and was in place at Bonneville in November of 2010, essentially there were a best qualified list was derived and a formula was created to set the parameters for the best qualified list. Veterans, by definition, if they met the best qualified list, went to the top. They had to be selected, or they could have rejected the job offer, but they had to be selected. What the Bonneville did is they adjusted the criteria after the fact. So instead of a rating of 90 to 100 falls in the best category list, it was modified from up to 95 being the lower threshold. And in effect, everyone who scored from 90 to 95 or 94, depending upon how the threshold was changed, was essentially excluded from consideration. And vets were in that, vets and non-vets. People who were entitled to veterans' preference and those that were not were essentially excluded from further consideration as a result of changing the bottom cut line.
Did you determine, you said vets and non-vets, so how did we get zeroed in on vets? In other words, if there are other people, women, African Americans, I'm just trying to figure out why we zeroed in on vets.
Well,
and don't get me wrong, I think it's very important that we address vets, but I'm trying to figure out, take me there. Just help me with that.
I understand your point, Mr. Cummings, I believe. First of all, the allegations that we received specifically indicated that vets had been disadvantaged. But you're absolutely correct. There was a population that was disadvantaged that included, most likely, and we don't know specifically because the reconstruction that's been talked about has not taken place, but it no doubt included women, minorities, a broad cross-section of applicants.
Can you, can you expand this is an ongoing investigation, is it not?
Yes, it is.
It's ongoing. Can you
Can I clarify?
Sure.
It's not at this point an investigation. Important distinction. It is an inspection and it's an allegation-based inspection, which
Can you
means
get
something
us,
to us.
would you supply us with the information as to the other folks that may have been discriminated against here? That may have been falling in that category?
It's going to, the answer is I can't do it immediately.
I know that,
Yeah,
but I mean.
no, at some point, the Department is going to have to go either internally or using consultants on a case-by-case basis and reconstruct each one of those vacancy announcements to provide the information that you're looking for, Mr. Cummings.
How many veterans are we talking about here?
If I knew the answer to that question, I could answer your earlier question. We don't know. But in 20 cases that the Department looked at, there were 35 vets that were disadvantaged in just 20 cases.
At this point, do you know why employees were doing this, and were they intentionally trying to exclude veterans, or were they just trying to reduce the number of total applicants they had to consider? And you've heard Ms. Decker's testimony that there may have been some confusion with regard to, how to do this scoring.
Well, let me try to break it down.
Break it down.
First of all, the Bonneville personnel indicated that there was confusion in terms of the policy and the procedure. I have no basis for disputing that, except that Mr. Cummings, a fair person who would read the direction and the policy, it was crystal clear. So I don't suggest that these people were misleading us or lying to us. I would suggest that the credibility in terms of that line of thinking was really in doubt. Secondly, I'm sorry, could you go back to the first part of your question?
No, I said, do you know?
Oh, yes. The Bonneville personnel involved indicated that the reason they did it, and you hit upon it in your question, was that they were trying to reduce the size of the pool that was going to the selecting official, to make it manageable.
And finally, Ms. Decker, as the Chief Operating Officer of BPA, let me give you an opportunity to respond to the IG's finding. Do you agree with the IG that BPA engaged in prohibited personnel practices during this time frame to the detriment of veterans? And my last question is, what is your sense of why this happened? Was it intentional? Was it poor training?
So, Representative, the bottom line is I agree with the IG's findings. We did apply and implement the category rating incorrectly. I think that there's not a dispute with Bonneville. Mr. Friedman stated that OPM found that DOA found that the IG found that. Bonneville also found that, and is why we stopped the practice. We found that we had implemented it incorrectly. I do not believe that it was intentional, because if you just kind of the rationale, if you consider that we moved the line, which that was the intentional act of moving the line, we intentionally did move the line. Why we did it was because we were misinformed or didn't understand how to apply it correctly. But when we moved the line, that line didn't then exclude all veterans, but it excluded that pocket of veterans. So say it was from 90 to 100%, and we moved the line to 95. Anyone that was in that 90 to 94% suddenly got excluded. But anyone that was above the 95% line, which did include veterans, in fact, still was referred to the hiring manager. I believe it was not an intentional act.
Do you think it was poor training?
I do believe that it was poor training. As I understand it, our folks had some training. I think the training was deficient. And I think that the retraining that is going on now will rectify that. But we did implement a faulty implementation. That's not in dispute.
Thank you. I just want to have Mr. Friedman follow up on the effect. And I'll run you through real quick numbers, and you tell me if this is correct. You've got 50 slots to be hired. You have 50 people in the top 5%, and you have 100 people in the top 10%. By going from a 10% mark to a 5% mark, let's assume for a moment that there are 25 veterans in the top 5 and 25 veterans in the second 5. If you take 10%, 50 veterans get 50 slots. If you take 5%, 25 veterans get the slots and 25 non-veterans get it. Is that roughly the arithmetic, the way it works, because veterans flow to the top The smaller the group, the more chance you have of essentially, with a given amount of slots, running out of veterans and taking other people. Is that what you found in your inquiry?
Mr. Chairman, I'm not sure I completely follow your numbers, but in principle, you have it right. But just let me clarify one thing. It's not going to the top. It's more severe than that. It is they must be offered a position. So they get a primacy that is extremely—
Right. And I said to the top in the sense that,
yeah, well,
if there's only 50 slots and there are 60 veterans, only 50 get offered. So it is very much like the gentleman said, and I think it's a good point. It's like civil rights discrimination. If you create an environment in which you exclude a group of people for whatever characteristic that would get something, they don't get it. And that is effectively what you found in your investigation. So misunderstanding 5 to 10, somebody probably understood the effect of how many of this particular group that uniquely would be offered a position if they were on that list. You knew you were excluding them by definition because you knew the size of the hiring, so you knew the size that you were not going to be included. And I think Ms. Decker said it. It wasn't always the same. It was 94 or 95%. Is that correct?
Well, I agree with you, Mr. Chairman, but I'd like to draw a distinction between recognizing that people who are entitled to veterans preference were, by definition, now below the line, therefore would not be considered, in contrast to saying that it was done intentionally to disadvantage the vets. I'm not there yet.
Well, okay. Well, we look forward to that continued process. And I'm going to go out of order to recognize the chairman of the full Resource Committee because he also has a hearing. Mr. Hastings.
Thank you, Mr. Chairman, for your accommodations and to allow me to come in here after my colleagues. I have been chairing a hearing on the transparency and the scientific integrity of the Endangered Species Act, not an insignificant issue. The subject of this hearing is of considerable interest to me for multiple reasons, both as a member of this committee with oversight responsibilities and also chairman of the Natural Resources Committee, which has jurisdiction over the Bonneville-Bauer administration and other power marketing authorities. That's why that interest is there. And it's also of interest to me because of the importance of upholding promises made to our nation's veterans and policies governing their hiring by Federal agencies. Lastly is of parochial interest to me because the district that I was elected to represent BPA is a very important part of that because it provides the wholesale power, the transmission to the greater Northwest. And I might add, Mr. Chairman, that agency is fully funded by ratepayers. As a result, the Northwest Congressional Delegation has long worked in a bipartisan way on overseeing BPA. So when it comes to these allegations, there clearly is bipartisan support in seeking the truth and ensuring that the appropriate responses to make certain BPA is operating properly so it can move forward in the future. There should be no doubt on the part of any person or agency that the Congress takes fair treatments of its veterans very seriously. Allegations of improper actions must be properly and carefully investigated. So I encourage the Office of Inspector General to be both thorough and timely in completing its reports. The full facts obviously need to be known. This is important. The full facts, which we do not have here today, are needed to be able to fairly and accurately assess the actions of BPA and DOE to determine how to move forward on this point. And let it be clear, the actions of DOE officials are certainly under scrutiny, at least from my perspective as the chairman of the Natural Resources Committee. Before these allegations ever came to light, there have been serious bipartisan questions about this administration's intentions as it relates to power marketing authorities, or PMAs. For months, dating back to last year, I've sought documents and information from DOE concerning what is commonly known as the Chu memo, a directive from then-Secretary Chu to the PMAs that threatened to arbitrarily increase the electricity rates of 40 million Americans in order to pursue questionable energy dictates. To be very blunt, Mr. Chairman, DOE has not been transparent in that regard. In fact, for months, DOT has been uncooperative in this remarks. DOE owes the Committee on Natural Resources their requests that they had for documents surrounding this. BPA and PMAs have an established mission under the law. This is important. And this mission should not be subject to political interference to pursue particular policy pensions of any presidential administration, whether that administration is Republican or Democrat. Oversight of both of these matters will continue from the perspective of the Natural Resources Committee, and I certainly intend to fully participate in any future actions by this committee. And once again, Mr. Chairman, thank you very much for your courtesy in allowing me to come here after leaving my hearing.
Would the gentleman yield briefly?
I'd be happy to yield.
Thank you. Secretary Poneman, I want to run very, very quick questions because the short response we received from Eric Figge?
It's Figge, sir.
Figge. We had asked a question about potential for retaliation and directives, and we got an answer saying that you didn't order or tell people not to respond. But I want to go through something quickly. Did you give a directive, verbal or otherwise, to anybody at Bonneville Power not to discuss the situation with anybody outside the BPA? In other words, did you have a conversation with somebody who then could have acted on your statements?
I certainly have frequently, Mr. Chairman, said we are one organization and we need to coordinate our communications when we are dealing with the outside world, yes.
Okay. So somebody could have taken your statement that we have to coordinate to mean that somehow people should only answer questions coordinated or talk to Congress on a coordinated basis.
I have no idea what they read into my statements, but as I said, Mr. Chairman, it is our policy that we speak with one voice, and we always seek to coordinate our messaging to the public, to the Congress, to the press, and so forth.
Well, Mr. Secretary, it concerns me that you say that. You don't have to coordinate the truth. You don't have to prepare to tell the truth. The fact is that we expect people to be told something closer to your original opening statement, which is that you're free to talk to Congress. It's not only your right, but it's your responsibility, and that although notification may in some cases, particularly classified notification, may be appropriate, that coordinating is a term or code, in my opinion, for come to us, let us tell you what to say, let's talk about what you would say. That kind of coaching is outside what we would consider to be a free exchange that encourages people to tell us, right or wrong, what they think happened.
Let me be very, very clear about this, Mr. Chairman, because I think this is a very important question that you raise. It is absolutely fundamental as a matter of fairness, as a matter of everything that we stand for and our management principles and everything else, that any individual, be they a Federal employee or a contractor employee, must be free at any and all times to cooperate fully, to step forward, to express any concerns, tutored or untutored, whatever is on their mind. They have to be free to step forward and say exactly what they think to anyone. I have been very clear about that consistently. That is a very different thing than assuring that one's policy responses in a very complex organization with a lot of different issues, river treaties, rate cases, and so forth. It is confusing and inaccurate if we then convey 115,000 views out of 115,000 people. So
now, we understand, Mr. Secretary, and I'm going to Mr. Lynch, but we have been told by staff at Bonneville Power they're under the impression they are not to speak to anyone outside of Bonneville Power Administration or DOE about this situation. That's their impression when they have said, well, I can't speak to you because that's my understanding. And, of course, that thwarts our investigation, which isn't that much of an investigation in the sense that we're very, very much just trying to look over the shoulder of the IG, get comfortable so that we can make an assessment on a government-wide basis. So we've been a little surprised that they have the impression that you say you're not trying to give them.
Yeah, I'm surprised too, Mr. Chairman, because everything I've said verbally and everything I've put out in emails and so forth has said everybody is free to step forward without fear of reprisal or retaliation. absolutely consistent
Or
on that.
coordination, hopefully, in the future will be.
Mr. Chairman, just unanimous consent to ask, you have 1 minute just to clear this up.
Gentleman is recognized for 1 minute.
Thank you very much. I want you to listen to what I'm saying very carefully, because I don't want misimpressions, but I also want to know your answer. You haven't done anything to stop anybody from telling the truth, have you?
Absolutely not, sir.
That's, I want to make sure that's clear, because we want the truth, as I've said it many times, the truth, the whole truth, and nothing but the truth. So that, I just want to make that clear. All right.
Thank you. Mr. Lynch.
Thank you, Mr. Chairman. I want to thank the witnesses for coming before the committee to help us with this. I'm the former chairman, now the ranking member of the subcommittee on the federal workforce, so I'm a big champion of veterans' preference. As a matter of fact, the distinguished veterans of the United States Armed Forces have enjoyed veterans' preference for hiring in federal positions since the Civil War, the American Civil War, and well-deserved, I think. The long-standing federal policy of veterans' preference in hiring was born out of our collective recognition of the immeasurable sacrifices that our brave sons and daughters in uniform have made on behalf of this grateful nation. The veterans' preference has been codified in law, including the landmark Veterans Preference Act of 1944 and the Veterans Employment Opportunity Act of 1998 and other federal statutes. And so it's a matter of law. It's not a suggestion. It's a priority that we've recognized, and it needs to be followed. These veterans have earned this. And it's important to remember that for this workforce that we're considering of veterans, the Gulf War veterans, Iraq veterans, Afghanistan War veterans, this is a volunteer force. And many, many, many of them have served multiple tours of duty where they have not only put their civilian careers on hold, but also their personal lives on hold so that they can serve this country. So these laws for veterans' preference also reflect our national commitment to ensuring that our men and women in uniform are not penalized because they've served multiple tours in Iraq and Afghanistan in the Gulf. So with that interruption in their civilian careers, if they don't get veterans' preference, they are penalized. So this is an affirmative step that we're taking to make sure that they are not penalized for their duty to this country. Now, I am greatly concerned by the Inspector General's preliminary findings set forth in the July 16th Management Alert. And I'm going to quote from him. He says, BPA engaged in hiring practices that, I quote, effectively disadvantaged veterans and other applicants and were inconsistent with the concerted efforts by the Federal Government to ensure that veterans receive appropriate preferential treatment in the hiring process. Ms. Decker, and I appreciate you haven't had much time to prepare, but I got to ask you, in the report, the alert says, quote, we have received a number of complaints from the HCM staff members alleging that they were disciplined because they had communicated hiring problems to Bonneville management, to the Office of the Inspector General, and or to human capital officials. You're aware of these allegations, correct?
I am, Representative.
Okay. Let's talk about a minute about these disciplinary actions, which trouble me greatly. Ms. Decker, in your testimony, you stated that while these actions are in my line of responsibility, I'm not the decision-maker on the proposed actions. That's your statement. Ms. Decker, which management officials at BPA were the decision-makers who proposed and implemented these adverse personnel actions?
Okay. Thank you, Representative. So just maybe talk a little bit about structure for a second.
No. We're not going to talk about structure and things like that. I want the names of the people. If you're saying it was in your line of responsibility,
yes,
and you didn't make it, and other people did, and you do go on to say about the process that was used, who were the individuals that we should be talking to that made these decisions not to hire veterans or to limit the number of veterans that we're hiring?
Okay. So, Mr. Representative, our Human Resources Director, in conjunction with the Human Resources Manager for Staffing, actually made, let me back up because I'm under oath. the decision on how the practice was implemented, I can't speak to who specifically determined this was the interpretation Bonneville would take. What I can tell you—
Wait a minute. In your testimony here that you gave to the committee, you say it was made with the consultation of a number of individuals. You said they were qualified. They made the decision, right down the line. And you're not going to tell me names.
No, so, Mr. Representative, what I said was that this was in my line of authority. I was not the decision maker. The decision— you're asking two different questions. One is who is making decisions on the performance management versus who is making decisions on the policy. So I'm not sure which answer—
Well, give me them both.
Okay,
give me
great.
one, then the next.
Okay. The decision on the policy for the implementation of the category rating would have been made by the manager in the staffing
Who's that?
organization. At the time that, I would have to go back and see who the manager was.
Wait a minute. You forget?
I'm not sure who the manager was of the staffing
Okay, let's
organization.
go to the next group, the other group that decided policy. You remember those names? You're under oath now.
Yeah, but what I'm not sure of is, in terms of the policy,
You got to be kidding.
it may have been Susan—
You've got to be kidding.
No, I'll give you names. It may have been Susan Burns. At the time, I believe she was the manager of the policy.
Is that BYRNS or BU?
BURNS.
All right, who else?
Briefly answer. The gentleman's time has expired, and I do think that, Secretary, that you and the IG probably could answer this for the record very accurately.
We're on the record.
No, I meant with qualified instructions within the line. I'm happy to have her, to the best of her knowledge, answer your questions, but I ran an organization that was only a few hundred people, and not being sure which person, and I built the company.
With all due
The gentlelady may answer.
With all due respect, though, we spent 20 minutes up here on a dance on what was personal, what was not personal. Now we're getting down to the brass tacks of who actually did this, and we want to defer the question. I mean,
No, I'm
this
not
is what
deferring.
we're here for.
Mr. Lynch, your time has expired. What I said was the lady—
Because I'm chatting with you.
The gentlelady, I know, the gentlelady may answer to the best of her knowledge or conjecture that it's one of a couple of people, but she is under oath. She does not have the documentation in front of her.
She has a memory, though. That's all I'm asking her.
And that's all we've said, but she has said she's not sure in a couple of cases. So, Ms. Decker, you may answer those questions to the best of your knowledge today, and the committee will ask the Secretary and the IG to provide such documentation so that we may verify the accuracy. Thank you.
Okay, so can we have you answer the question?
I will answer the question. So I will answer the question. I have 2,700 people that report to me, knowing specifically which manager, 4 levels down, that made a decision on implementing a policy. I am not as clear about who that specific person was, although I believe the name I gave you is accurate. In regard to the performance management decisions were made by first-line supervisors, not all the same supervisor, and someone who was an employee relations specialist who was trained to work through performance management issues with a manager, and different representatives of Bonneville Legal Counsel. They are each handled individually, given the circumstances of the performance.
So they all on their own decided to go to this 95% level?
No, excuse me, Representative. I was referring to the individuals that have come under disciplinary or scrutiny or performance scrutiny are not necessarily all in the staffing organization.
Thank you. The gentleman's time has expired. We now go to the gentleman from Houston, Mr. Chaffetz.
Thank you, and thank you all for being here. Mr. Friedman, when did you first learn about the problems that we're talking about today?
The first allegations were received in June and August of 2012.
And are you aware of any BPA whistleblowers who contacted your office who now face adverse personnel actions?
The answer to that is yes. Well, face or faced, there have been intervening actions that have taken place.
Well, explain what has happened to these people.
Well, in one case, a person was escorted off the property and told that placed on a suspension in anticipation of being relieved of his or her responsibilities.
And you believe that the reason for that was because they had contacted your office?
I am relying upon what they told us. They felt they were being retaliated against for raising this issue either to our office or to Bonneville's management itself.
Was there more than one person that went through this?
Variations on the theme, yes.
How many are we talking about?
Well, as the Chairman alluded to, it's at least 5 or 6, and we've received additional allegations since our report was issued. We're sorting through those right now.
What effect has this had in your investigation?
Well, it has a chilling effect on, we don't know. We can't gauge that. But obviously people who are concerned about their jobs may, that's the whole point of protecting these people, they may feel that if they're going to be retaliated against for coming forward, that they will be reluctant to do so. So it's an unknown. I can't prove the unknown.
But there's obviously a current, and that's one of the concerns, is there starts to be a current here that is a very either direct or indirect. When Mr. Poneman's comments are baffling to me, quite frankly, sir. On the one hand, you talk about the great openness and transparency, the great ability for anybody to come forward. At the same time, you have people who say, well, we were told not to. We were going to coordinate. We were, in fact, in this letter of July 24th of 2013, the Deputy General Counsel wrote to Chairman Issa, rather, Bonneville was informed that this is a very serious matter and that any external questions were to be coordinated with the appropriate headquarters office as if the United States Congress was an external organization. Mr. Friedman, doesn't that strike you as a contradiction? Doesn't that strike you that if you're going to coordinate, isn't that sort of code for you better not say anything unless headquarters approves it?
You're asking me for an interpretation, Congressman Chaffetz, and I could interpret it one of two ways. I mean, both. I could interpret it either way, frankly. One is that it is a code, but I prefer the more benign interpretation, which is that in an organization, you do interpret things, you do coordinate things. That's the way things get done. Things are accomplished.
But that's contradictory to the idea that if management, if the Washington, D.C. is going to take the point on answering these questions, you better let them answer those questions rather than you as an individual feeling free to express your personal point of view and your personal experience. Is that a leap too far in your mind?
No, I don't think that's a leap too far, no.
These allegations of retaliation.
May I comment on that?
Not yet, not yet. Allegations of retaliation. Again, any sense of how far and wide this might be?
Well, as I indicated earlier, I think we have 5 or 6 cases that are sort of ripe or getting ripe, but we've had other allegations since the issuance of our report, and we don't know where those stand at this point.
Mr. Poneman, we've had a very senior official there say that you did give a verbal order to Acting BPA Administrator Elliot Mainzer that nobody at BPA was allowed to talk to anybody about the situation. Do you take issue with that?
I have no idea what others have said. I can tell you what I said, and I've talked to Mr. Mainzer, and I've been clear beyond peradventure that anybody may step forward. I said this to him verbally. He repeated it in an email to the staff. I don't think there's any ambiguity whatsoever.
I beg to differ, Mr. Chairman. I think as we talk to these whistleblowers, and God bless them for stepping forward and offering a perspective, it needs to be in context and with an objectivity. I appreciate, Mr. Friedman, for your diving into this issue, and we look forward to your continued experience in sorting this out.
I thank the gentleman. We now go to the gentleman who represents a great many Federal workers, Mr. Connolly of Virginia.
Thank you, Mr. Chairman, and welcome to the panel. Mr. Friedman, I'm puzzled by what my colleague, Mr. Chaffetz, just said. I worked in the private sector and I've worked in the public sector. I headed up a very large government locally here. It would be unthinkable in either of those enterprises that people could just Lone Ranger responses to the Hill. whether it was written inquiries or whether it was a request to testify, you absolutely had to notify your supervisor, and you absolutely had to coordinate it. Otherwise, there's chaos. In the private sector company I'm talking about, we had 46,000 employees. And in the public sector employee I'm talking about, we had 36,000 employees, including school employees. What could go wrong with allowing everybody to do whatever they wanted whenever there was an inquiry here in the Hill? That's a recipe for chaos, is it not, Mr. Freeman, as a management principle?
I certainly see that possibility.
Thank you. So the idea that somebody might coordinate in no way, shape, or form on its face suggests anything other than that very word, coordination. That's a fair interpretation too, right, Mr. Freeman?
I think it's a fair interpretation.
So the idea that putting a sinister interpretation on that word is certainly one interpretation, and Mr. Chaffetz would have us believe apparently that's the only interpretation. But I beg to differ as somebody who has managed large enterprises and been involved in the management of large enterprises, both in the public and private sector, dealing with this very subject. And frankly, given what could go wrong with Federal employees coming before this committee especially, I would think coordination, lack of coordination, would actually be a reckless management act.
Would the gentleman yield?
No, I will not. Mr. Deputy Secretary Poneman, it seems, based on what we're looking at, that the Department reacted very aggressively to these allegations and took some strong message. So I was surprised to learn that Chairman Issa publicly accused you of muzzling employees and obstructing the committee's investigations. I mean, those are serious words. So I would like to give you an opportunity to respond publicly. On July 17th, Chairman Issa sent you a letter that said, and I quote, "Today I learned on Monday that would have been July 15th, you verbally instructed Elliot Mainzer, the individual you chose to act as acting administrator of BPA, that no BPA employees were to talk with anyone regarding these allegations, including congressional investigators," unquote. Did you, in fact, Mr. Poneman, instruct Mr. Mainzer that no BPA employees were to speak with congressional investigators?
No, sir, I did not.
Have you any idea why the Chairman would make such a charge when your testimony under oath here today is flat out you did not do such a thing?
No, sir, I don't know what information he was basing that comment on.
Can you tell us what you did tell Mr. Mainzer?
Absolutely, sir. I told him that it was imperative, as I have maintained consistently in all communications, that everybody understand clearly that there can be no retaliation, no reprisal, no adverse action taken to anybody for stepping forward and expressing their concerns in any case. And in fact, he followed up that conversation with a communication to all BPA employees to that precise effect. So I think he understood me rather clearly.
Did you ever instruct anyone to muzzle BPA or DOE employees?
No, sir, I did not.
Chairman Issa next warned, and I quote, "Obstructing a congressional investigation is a crime." Now that sounds a little bit, well, it echoes a tactic used in a previous era that's most unpleasant. And if the Chairman really believes it's a crime, then presumably this committee will pursue it to the fullest. And then he, in fact, reminded you that that crime statutes have a 5-year prison penalty, which seems deliberately designed to intimidate you. But maybe he felt you just needed to be reminded. The very same day, however, that Chairman Issa claims you ordered the muzzling, the Department sent its official response to the IG explaining that you had personally directed Mr. Mainzer to instruct employees to cooperate. Can you explain this seeming contradiction between the Chairman's conviction that a crime almost had been committed and apparently your official response directing Mr. Mainzer to, in fact, cooperate?
Congressman, I can only speak to my own actions, and there, as I said, I've been consistent that anybody in any setting, be they a Federal employee or a contractor employee, has to feel free to step forward and express any concerns that they may have to any properly constituted authority. So I've been quite consistent on that. It never would even occur to me to seek to be obstructing any such inquiry, frankly.
And if I could just, Mr. Chairman, one last question to the IG. Anything Mr. Poneman just said to this committee under oath.
We have no allegation, if that's what you mean, Mr. Connolly, that Mr. Poneman has muzzled anyone.
Do you have any information? Did anyone come forward from DOE or BPA to suggest to you that they had been intimidated or coerced or discouraged from cooperating with this committee in any way? Do you have any evidence of that as the IG?
Not for Mr. Poneman, with regard to Mr. Poneman.
Thank you. Thank you, Mr. Chairman.
Thank you, Mr. Poneman. You're Deputy Secretary. You're the #2 guy at the Department of Energy. Is that correct?
Yes, Mr. Chairman.
And you've been there since 2009?
Yes, sir.
And you head up the Credit Review Board. Is that accurate?
Yes, sir.
And were you on? So you were on the Credit Review Board when decisions were made regarding giving taxpayer money to Solyndra. Is that correct?
Actually, the original Solyndra decision, sir, occurred
Were you part of any discussions about the money, the taxpayer money that was given to Solyndra? Were you on the Credit Review Board when some of that was discussed? Yes or no?
The subsequent issue that came up later when the loan was in trouble was when I was at the credit.
Yeah. And what's the status of Solyndra today? Isn't it true that Solyndra is bankrupt?
I believe it's bankrupt, sir.
Okay. And so were you on the Credit Review Board when Abound Solar was given taxpayer dollars as well in a loan guarantee?
Abound was during our tenure, yes, sir.
Yeah. And isn't it true that Abound Solar is bankrupt today as well?
I believe that to be the case.
Okay. And were you on the Credit Review Board when Beacon Power was given a loan guarantee?
Yes, sir. I would note that there are millions
isn't it true that Beacon Power is bankrupt? Isn't it true that Beacon Power is bankrupt today?
Yes, sir. And I would also note we have the largest wind farm in the world. We have the largest photovoltaic
farm
in the world.
I'm asking the questions here. So, and you were on the Credit Review Board when the decision was made to give Fisker a loan guarantee. Isn't that true?
Sir.
All right.
And I was also there when Tesla repaid their loan early, sir.
I got that.
Okay.
Maybe we'll get to that. Wait, I got a series of questions. And isn't it true that Fisker's in serious financial difficulties, have failed to meet the milestones
Sir, I'm not
established by
prepared
the
to address the Fisker matter today.
Yeah, well, we had a hearing, and they're in big trouble. And isn't it true that you were on the Credit Review Board when Nevada Geothermal was given taxpayer money?
I would have to look at the record, sir.
Yeah, we think it was. And isn't it true, Mr. Poneman, that you were on the Credit Review Board when Solo Power was given taxpayer money as well?
I have to look, sir.
And isn't it true, Mr. Poneman, that almost $15 billion of taxpayer money in the loan guarantee program was given to 26 different projects? Is that accurate? 14.5 billion, 26 projects?
We have deployed billions, and we've leveraged more, and we have to show for that large wind farms, large solar farms, and a very,
and isn't it true,
very
Mr.
small
Poneman,
default rate, sir.
And is it true, Mr. Poneman, that 22 of those 26 projects had a credit rating of BB-, commonly referred to as junk status?
Sir, I would have to look at.
Well, we've looked at the emails from Department of Energy, and we've looked at the facts, and that is in fact the case. And now we find out, as I look at this flow chart where it says you're #2 or this chain of command, that you are also the one directly responsible for Bonneville Power Administration. The line goes directly up to you, and we find out that this agency, or this Bonneville Power, was discriminating against veterans. We find out from Chairman Hastings that the Department's been uncooperative, was the term he used in the inquiry he's made. The Chairman has said you have not been responsive. And then we also find out from Mr. Friedman that there's retaliation going on at Bonneville Power. All this is causing me concern about what's going on in the Department of Energy.
Sir, we always seek to be responsive. We provide thousands and thousands of documents. We have consumed less than 10% of the loan loss reserve set aside, which I think is a not bad record, even in the private sector. We are always responsive.
How many more billions of dollars? How many more billions of dollars do you plan of loaning out of taxpayer money to other projects over the course of this next year, Mr. Poneman? Do you have any idea?
We'll have to see how many.
You think your track record is going to get better than, or some of these loans you're going to give to these projects going to be better than BB- rated companies?
Sir, the portfolio is healthy. It's been looked at. It's being managed actively.
3 companies bankrupt, 4 on the verge of bankruptcy, and you call that healthy? That's 7 out of 26.
Sir, we've consumed less than 10% of the loan loss reserve. The default rate is very modest.
7 out of 26, 22 out of 26 double B minus rate. Let me just put up one other thing. I want to ask you this question. This is an email that we received. We'll make it available to everyone. This talks about you were recused from decisions regarding Fisker. Tell me why you had to be recused from, because you told me that you were on the Credit Review Board when a decision was made about Fisker, but this says you were recused from that. Why were you recused, and tell me the circumstances around that?
Sir, in 2009, 2008, I beg your pardon, there was a presidential election coming up. I had begun to make some inquiries as to whether I might need post-government employment engagement, and so when you have engagement with entities, you file recusals, and that is what I did.
What was the entity that caused you to? You were talking with Fisker directly, or who?
No, of course not, sir.
Okay, but so why? So I'm still not clear. The Deputy Secretary is recused from Citibank. Citibank is involved in several loan guarantee deals, and they list Fisker there. So you were recused because of your involvement with Citibank?
I beg your pardon, sir?
You had to recuse yourself from discussions about Fisker because of your involvement with Citibank?
I had a conversation with Citibank, which led me to recuse myself from anything that—
When did the conversation with Citibank take place?
I do not— I can't recall the exact date. I'd have to come back to you. This is a hearing on a different topic, and I had not prepared for this.
Well, let me put up another slide, because I just want to ask you then, because I'm curious, because we have the minutes from the April 11, 2012 meeting, and as we go through the minutes, there are several questions. The next project for review was Fisker Automotive. The Deputy Secretary asked if any of these problems are related to issues with A123 battery. The Deputy Secretary asked the company, was it adhering to his business? The Deputy Secretary asked this. The Deputy Secretary. So you're critically involved in discussions about whether taxpayer money was going to go to Fisker, which we know is on the verge of bankruptcy, and yet we also have the email saying you're supposed to be recused from any discussions about Fisker. So what I want to know is,
Mr. Chairman.
I want to know the timing of this whole process.
Mr. Chairman, yield.
Be happy to yield.
Just very briefly, I've tried to sit here and listen to this line of questioning that has nothing to do with this hearing. And Chairman Issa and I have tried to—
if I could, to the Ranking Member, I think it goes to the performance of the Department of Energy as a whole. And obviously, when you're discriminating against veterans, you have to recuse yourselves from taxpayer money given to organizations. I think it all is applicable.
I think that the other thing that I'm concerned about, you're asking Mr. Poneman some questions, and I want him to be frank and honest, but at the same time, he didn't come prepared, I don't think, to answer these questions, as you can see it over and over again. But, I just think that we ought to try to stay within the limits of the hearing. That's what this subject is. I tell my members that on this side to maintain some type of order, or else, we can go over a whole landscape of things and not really get to the bottom line here. But I reluctantly even mention this because I do believe in a certain amount of latitude, but at some point it just gets out of line.
I appreciate the Ranking Member's comments. I would just say that Mr. Poneman is the Deputy Secretary, basically runs the Department of Energy's _2 guy there. I asked him a question early on in my 5 minutes about his involvement with the Credit Review Board and Fisker. He said he was involved with that decision. Then further asked him about why he had to be recused subsequently from decisions regarding Fisker, and highlighted what we have in the emails. We'll be happy to let Mr. Poneman get back to us with an answer, but you would think the #2 guy at the Department of Energy would know what he did relative. He was just bragging about what a great program this is. You'd think he would know with respect to Fisker when he had to be recused and why he's in the minutes from the meeting where they were deciding to give taxpayer money to Fisker, a now bankrupt company. Sir, you would think he could give some of those answers to us.
Sir.
Yes. Gentleman,
with due respect, sir, I did not act on Fisker at any time after which I was recused, period. Thank you.
Yeah, I'm asking when were you recused? That's what I want to know. When was the date?
We'll provide you the date, sir. I did not come prepared for this line of questioning.
Okay. Gentleman from Michigan is recognized. The Chairman one? Gentleman from Michigan is recognized.
I thank the gentleman. Just to make sure I have an understanding. Mr. Friedman, are you aware of any BPA whistleblowers who contacted your office who now face adverse personnel actions?
I'm not trying to put too fine a point on my answer, Congressman, but they faced, past tense, potential action, yes.
What adverse actions did they face?
Possible suspension.
What effect does whistleblower retaliation have on IG investigations?
It has a potential chilling effect on our ability to get people to be forthcoming, candid, and cough up information that is essential to our work.
So do you feel that the threat of retaliation by BPA prevented other whistleblowers from coming forward, as well as having a chilling effect on these whistleblowers?
I can't, to paraphrase a former Secretary of Defense, I don't know what I don't know, and I can't be sure that there were people who—
Your best professional opinion.
My best professional opinion is it put a chilling effect on the work that we do, but the original whistleblowers, if I may, were people who brought the problems with regard to a veteran's preference to the attention of Bonneville's management. And then there were others who brought it to our attention as well.
Okay. Well, thank you. Let me go from there to Ms. Decker. At what time did you become aware of retaliatory adverse personnel actions?
So, Mr. Representative, I'm not aware of retaliatory adverse actions.
None?
No.
Then what role did you play in the disciplinary process?
In the adverse actions that are in question. So there are adverse actions at play. I would submit they are not retaliatory. I am not a decision maker in those, but the role that I played when they came to my attention—
Yeah, that's what I'm asking, the role you played.
The role I played when they came to my attention was to understand, had there been consideration of the whistleblower impact, and had there been consideration for the due process of managing performance. The answer I got, the response I got from our legal counsel was that, yes, those things had been weighed, and yes, there are risks, but that it did not preclude proceeding with the adverse action in terms of performance accountability.
What specific role did other BPA employees play in the disciplinary process that you've described here?
Representative, as I started to say earlier, the individuals in question have a supervisor. The supervisor is best equipped to determine the performance of an individual. So the supervisors was involved in terms of the individual's performance. Beyond the supervisor, at Bonneville, our practice is to have someone from legal counsel and to have an employee specialist work with the manager. In part, that is to ensure that there is not retaliatory actions, that legal counsel and the employee relations specialist are watching for that as someone goes on to a performance action.
So you personally took no actions in relationship to allegations about retaliatory actions or discipline?
What I did—
Is that
no.
correct understanding?
That would be depending on how you look at that. So what I did do, my responsibility was to ensure that we actually are following the processes that protect employees and protect the agency. I did that. Again, I want to underscore, there was a first-line supervisor, a manager, a director, another executive vice president before it got to me.
Do you think the actions were fair, ultimately?
Ultimately, I believe in the process that we use, and yes, I believe that they are fair.
Let me go further here. Randy Hardy, former BPA administrator, recently stated that the BPA employees claiming retaliation are, quote, poor performers who claim to be whistleblowers. He further stated that that's a frequent problem with whistleblower laws. Do you agree with Mr. Hardy's statement that the whistleblowers are poor performers trying to insulate themselves from disciplinary action?
Let me say this in terms of Mr. Hardy's comment. In this case, I don't know the facts to know whether that is true in this case. I think there is appropriate whistleblowing. I think that is an important function that's played by anyone who brings something forward. The issue of someone's performance is oftentimes a separate issue. And I would not categorically say that someone who is whistleblowing is doing it to protect themselves from performance. But I also know that management cannot turn a blind eye to performance because someone has a protected status. And there is a chilling effect upon managers as there is upon as well if their view is they cannot take any action.
But Mr. Hardy went on to say that he thought that that was exactly what was at work here in this instance. And that's a concern. And that's not general statement, that's specific to this issue.
And that's Mr. Hardy's opinion?
Is that your opinion?
No, that is not my opinion.
Thank you. Thank you, Chairman.
Thank you. Now going to the gentleman from Indiana, Mr. Langford. Oh, excuse me, Oklahoma.
I'll take it. Indiana is a great state as well.
Yes,
but if I have the option, I'll take Oklahoma just personally for me. Two lines of question here. Ms. Decker, first on it. You had mentioned before in your oral testimony that a mistake was made a year ago and that mistake's being fixed. Can you clarify what you mean by the mistake?
So Bonneville did implement the category rating process incorrectly, as Mr. Friedman articulated. That was a mistake. In terms of fixed, I would not call that it's fixed. I would say that improper application of category rating has stopped. What is not fixed is the reconstruction of those jobs during that time period that impacted veterans. We have not fixed that yet. So we stopped the erroneous practice. And we stopped it because we also saw that it was incorrect. If we didn't think it was incorrect, we would still be doing it. And the fact of the matter is we stopped back in May 2012.
Okay. Thank you. Mr. Poneman, let me ask a little bit about just direction for all the PMAs. And while Bonneville is the one obviously we're addressing on this now, is there an emphasis right now between DOE to try to say, okay, we need greater oversight over all of these different entities at this point? Is there more of a regional focus, decision-making? Where do you think the trend is going right now as far as how decisions are made, whether it be personnel or function or direction?
I don't think there's a trend, Congressman. As you note, all the power marketing administrations fall under the authority of the Department of Energy. They are part of the Department. They have various different legal authorities and various and different traditions. We seek to have good cooperative, coordinated relations with all of them, and I think to a large measure we do.
Right. Secretary Chu had written a memo back in March of 2012 that talks about just increasing to work on incentivizing energy efficiency programs, integration of variable resources, preparation for electric vehicle deployment and such. Are you familiar with that memo?
I do recall it, sir.
Yeah, it's just the preparation and the direction that it needs to go on it. And a general question on this, and it's a difficult one because multiple administrations, both Republican and Democrat, for the last 30-plus years have considered the PMAs and Bonneville specifically as an entity that should be privatized, that should be sold. And allow the power to go back to the market as it does to other areas. What is the consideration? While the consideration is happening in DOE about functioning with how we need to direct the different PMAs, is there also conversation about is this something that should be on the market like other power distribution is?
Sir, the conversations I've had about the power and market administrations, as far as I can recall, have not touched on privatization per se. I would note that when there was so much concern generated by that memorandum that we took account of that, and we had a whole, as I think you know because they included your region, a whole series of working groups, and we brought a lot. I think it turned out to be a very healthy exercise to bring a lot of perspectives to bear in a so-called JOT program that I think ended up providing a lot of very useful information and a lot of good feedback with good policy direction rolling forward for the PMAs.
Okay. What happens if in the days ahead this Congress were to look at it and say, okay, let's do an experiment. Let's pilot. Let's find one of these areas and be able to sell it, and to be able to have the power that's generated for that area on the private market as it does in others. And I'm very aware of all the parochial concerns that immediately folks from that area panic and say we won't have electricity in our homes because it'll be on the private market and all that kind of stuff, as it is in multiple other areas. They're terrific assets that are there, but it's also a liability to us, the line of credit, and it has a history over the past 30 years of sometimes making money and sometimes being a stretch on the Federal budget. So the question becomes, what would it take, and are there considerations about selling any of these assets?
Sir, I'm not aware of any conversations of that character. We are right now, of course, most directed by the statutory bases of all 4 PMAs, which are different. Yeah, the thing that we are very focused on is they generally require us to provide the least power available to the preference customers and so forth. And I'm aware that there's been a lot of interest in the ability that has had in generating economic growth in the region served by the PMAs.
Correct. But, yeah, this is not just a Republican issue. Democrat administrations have brought this same issue up as well over the years, to say this should be a serious consideration to be able to look at, not only for budget realities, but just for fairness for the community that's there and for the Federal taxpayer nationwide to look at it. So what I'm interested in is, are there conversations like that have happened in DOE?
Not that I've been party to or aware of, sir.
Okay. Thank you. I yield back.
I thank the gentleman. We now go to the gentleman from Michigan, just north of Indiana.
Thank you, Mr. Chairman. I do apologize for, I did know he's from Oklahoma. Getting back to veterans and hiring preferences, you know, I'm a little, I think I have a unique clarity because I am a Vietnam veteran as well as Iraq. And I remember coming home from Vietnam and applying for work, and people, my fellow veterans, were telling me, don't put Vietnam veteran on your resume. You'll never get hired. And so I think I have a unique clarity. And what was really upsetting to me when I read this, it said that one of your middle managers, he or she would never again hire a Vietnam veteran. That was a comment made by the report from a whistleblower after they heard this from a middle manager. Have you ever served in the service? Mr. Pullman? Yes. Pullman, how do you pronounce that?
It's Poneman, sir.
Poneman, thank you.
My father was a World War II veteran, but I, sir, have not served, but I strongly honor all service and honor you for yours.
Thank you very much. But, you know, I hear that a lot, too. Thank you for your service. Now get lost.
Yeah. And, sir, this is precisely why we are as forceful as we are in ensuring that the veterans' preferences, which are codified in law, are fully and faithfully executed.
Did you ever talk to your father about his experience in World War II?
I absolutely did many times. We lost him many years ago, sir, but he served in Burma, he served in China, and he was in the Signal Corps, and it was a formative experience for him. And by the way, he benefited from the GI Bill and got some college education afterwards, so we had a strong tie on that.
As did I, and thank you for his service.
Thank you, sir.
A lot of veterans tell me that when they come home, it's kind of like watching a movie. It's a 3D movie. Everything's live around them, but because they, I guess, experience something uniquely different than everybody else, it was like watching a movie. They weren't really actually part of what they were watching because there was, you know, this difference. But on the whistleblowers, Mr. Friedman, any of those whistleblowers veterans?
I don't know.
Did you ask? You had about 5 or 6, right? And others?
That's an interesting question. I don't believe we've posed that question.
Okay, very good. Just a few more questions. Let's see. Those escorted, let's see, you had 146 cases of applications or people you were hiring. Was that the extent, and what was the period? 2 questions. What was the period of hiring that we're discussing, and how many openings for jobs were there?
Well, as I indicated, those are our preliminary numbers. It covers a period of 2010, November 2010 to 2012, April or May of 2012.
Okay. So out of the 146 cases, right, and you said there were, how many hired were actual veterans? Or
I don't know how many hired were actual veterans. What I have said is in two-thirds of the cases, the veterans were, or there were prohibited personnel practices in which veterans were disadvantaged.
Did anybody tell you why, other than this comment I hear that they bond with each other too quickly and undermine management? I don't understand how that.
Well, in terms of the actions that were taken by Bonneville, what we were told by the hiring officials and the program officials is that they wanted to reduce the size of the pool they had to deal with for selection purposes.
Why do you think that is? You know, I have a real hard time with that because, well, go ahead, answer.
Yeah, I have a hard time with it too. That's why we're doing what we're doing.
Yes, I understand. So, let's see. I had one other question. I can't remember what it is, so I'll yield back.
Would the gentleman yield?
Yes.
Mr. Friedman, I'd ask that you give the committee the effective numbers, do the analysis based on the known pool of how many veterans would have been in the pool had it been at 90% and how many were in the pool each time at a different number. I think both the ranking member and I, I'll let him have the rest of the time, would like to know the effect of this change, even if we don't know the intent.
Mr. Chairman, let me be totally candid with you. That question cannot be answered with any precision until all the files have been reconstructed, and that is going to take. That's not something that I can do.
Sure,
something that Bonneville is going to be doing and the Department is going to be doing. It's going to take months before that is done.
I appreciate it. We'll be patient and we'll take partial reports as they become available. Mr. Cummings.
Thank you, Mr. Chairman. Just one quick question. How do you correct this? In other words, I mean, we talk about correction. Discrimination is a booger-bear. It's criminal. Because basically what you've done is deprive these veterans of opportunities, and it just doesn't affect them. It affects their families and generations probably yet unborn. I haven't even gotten into the frustration piece. But, I mean, Mr. IG, Mr. Friedman, are your recommendations going to go into, if you were to find these violations, will they go into any kind of corrective action? But thank you very much. I appreciate it, Mr. Chairman.
Well, Mr. Cummings, if at the end of the day this pans out the way it is headed right now, it's going to take some time, we're going to have hopefully recommendations that will get to the root causes of the problem, at least the proximate causes of the problems at Bonneville. We're hoping that there will be lessons learned. I mean, frankly, this whole exercise will have been for naught if there aren't lessons learned that can be applied certainly throughout the Department of Energy and perhaps beyond. And that's our hope. Part of this, though, is a question of judgment. And, Mr. Cummings, I don't know that you can regulate judgment or legislate judgment. People here knew there was a problem and didn't correct it at the source. And that's a judgment call, and I'm not sure how you correct that, to be honest with you. It's frustrating.
Well, thank you. We will look forward to finding out how we do that with the Secretary. Mr. Poneman.
I would just like to add to that. We will certainly benefit from whatever the IG finds, but our responsibilities are not abated while he's doing his work. And I just want to assure Chairman and Ranking Member that we have sent out and we continue to send out support. We have people actually on the ground now instructing on how to execute these laws and responsibilities appropriately so that the veterans' preferences are fully respected. We're not awaiting the outcome of any investigation to make sure we try to get at the actual practices themselves and correct them so that these problems don't recur and we fix them where they have occurred.
Well, we appreciate that, and I think what the Ranking Member and I are both getting to is you've got a pool of people who may have gone on to other jobs, may have done other things. They may not even be interested in these positions at this time. But until you essentially stop hiring anyone else, look and find these people and offer them a job, you won't at least have corrected the portion that is still within correcting.
And we are on that, Mr. Chairman. We are working that issue.
Mr. Chairman, I am so glad you said what you just said, because because you're right. These are people who lost out on an opportunity, and they probably can identify them. And I'm hoping that I'm so glad you said that, because it's just one of the ways, at least, for people who, if we find out that they definitely were discriminated against, they might at least have an opportunity to be brought back into a pool, which they should have been in from the very beginning. And so I do appreciate that, Mr. Chairman, and I would hope that we would follow up on that.
Yes, sir. Ms. Decker.
So, Mr. Chairman and Mr. Representative, if I could comment on that. There is a process to reconstruct, and that is what we need to get after. I think that is Bonneville's hope to get that done, and it's DOE's. I think that is one place I can say there's agreement that that reconstruction process needs to take place. And yes, we can identify the pool of folks that have been impacted.
Okay, well, we're going to go to Mr. Gowdy, who's been patiently waiting. But, affirmative action must be done quickly to have any real effect on the lives that have been disrupted as a result of wrongdoing. The ranking member said generations unborn. We don't want to wait for the generation unborn to be offered a job at Bonneville.
I hear you.
Or at some other equivalent place, which are within the Department of Energy's ability. You have a very large pool. If you had that entire list and you could offer them an equal or greater, you could go a long way toward a corrective action. And we are talking affirmative action here. We're talking about a group that's been discriminated against. They deserve to be recognized quickly, and corrective action separate from accountability. And I think that's what the ranking member and I are so dedicated to, and why we're really having this hearing today. The gentleman from South Carolina, Mr. Gowdy, thank you for your